Each country in the world creates, interprets, and enforces its own copyright laws. The force of those laws reach no further than the country's borders. To put the same point a bit more formally, copyright law has no extraterritorial application. Suppose, to illustrate, that I'm an American musician. I write and record a song in the United States. You're a French musician in the United States on vacation. You hear the song broadcast on the radio. You like it, you return home. Then, without my permission, you make your own recording of the song in France and sell copies of that recording in France. Or you perform the song in a public venue in France. US copyright law will not reach your behavior because none of the acts that might violate my exclusive rights under US law occur in the United States. French copyright law might, because the acts at issue occurred in France, but only a French law shields US musicians, like me. In any event, US copyright law won't apply to your behavior. As you might imagine, new technologies are making the application of this principle more difficult. For example, which country's laws apply when a radio or television broadcast that contains some copyrighted material originates in country number 1, but is then received and watched by viewers in country number 2. A pair of judicial decisions in the United States take the position that such acts are governed by the law of country number 2, and thus that a Canadian broadcast received by American viewers is subject to US law. More litigation involving analogous borderline issues will surely arise in the future. But putting such complications aside, the basic principle is clear enough. Each country adopts its own copyright laws, and those laws only apply to acts in that country. When a country develops its own copyright law, may it discriminate in favor of its own citizens or residents? In other words, may it disfavor foreign authors? For a long time, the answer was yes. And indeed, until the late 19th century, it was common for countries to deny copyright altogether to foreign authors. For example, until 1891, works by foreign authors first published outside the United States received no copyright protection at all in the United States. Foreign authors, most famously Charles Dickens, and some US authors, denounced this practice and sought reform of the US copyright law, but to no avail. What underlay this practice? What would prompt a country like the United States to discriminate against foreign authors? Several forces seem to have been at work. Simple nationalism is part of the explanation. A more complex explanation is that copyright protection is often thought of as a tax on consumers. By granting an author exclusive rights, copyright law enables the author to raise the price of copies of his or her work and to charge more for admission to performances of those works, thereby forcing consumers to pay more for copies or performances. The rationale of that price increase, of course, is to provide a reward or incentive for creativity, a rationale that we will return to and examine in much more detail in subsequent lectures. For present purposes, the crucial point is that copyright protection causes price increases. Historically, many nations were reluctant to force their own residents to pay those increased prices if the monies thereby raised were to be paid to authors in other countries, even or especially if the result would be to stimulate creativity in those other countries. Attitudes of these sorts help to explain the origins of the practice of discriminating against foreign authors. Perpetuation of that practice, however, is probably better explained by interest group politics. For example, as Bill Patry has shown, in the United States during the 19th century, many businesses came to depend financially upon their privilege to print and distribute inexpensive copies of British books. This included publishers, printers, and bookbinders. Not surprisingly, when legislative proposals to end the discrimination against foreign authors arose, the interest groups that would have been hurt by the change lobbied against it. They were successful until 1891. Indeed, when the law in the United States was eventually changed, the publishers and printers were able to secure an important qualification. Copyright protection was extended to non-resident foreign authors, more specifically, to foreign authors from countries offering similar protections to US authors, but only if the copies of their works were manufactured in the United States. This protectionist measure, known as the Manufacturing Clause, was eliminated with respect to foreign authors in 1955 and eliminated for US authors in 1986. Its significance for the present context is that it illustrates the ways in which the financial interests of an industry often congeal around a particular set of copyright laws and then retard any modification of those laws. We'll see several other examples of that dynamic later in these lectures. Now let's return to the main thread. As we have seen, one byproduct of the principle that copyright protection is nation-specific and has no extraterritorial application is that countries could, and for a long time did, discriminate against foreign authors. Another important byproduct is that historically, copyright laws in different countries differed dramatically. Here's an illustration that we will consider in more detail later in the course. Countries in continental Europe have long accorded generous protection to what is referred to as droit moral, loosely translated in English as moral rights. These rights are said to be non-economic. They shield the personal or personhood interests of authors and artists rather than their interest in making money. For example, moral rights forbid the purchaser of a painting from defacing it or obscuring the identity of the artist who painted it. Such acts might not damage the artist financially, but they threaten the bond between the artist and her creations. By contrast, countries whose legal systems were primarily influenced by Great Britain have long been more skeptical of these moral rights. Such countries include the United States, Australia, New Zealand, and so forth. The upshot is that the existence or force of moral rights traditionally varied sharply across the world. The more general point is that, historically, the entitlements enjoyed by authors and artists were quite different in different countries. That's where things stood in the late 19th century. Widespread discrimination against foreign authors and wide divergences among the laws in different countries. There then began a long process, which continues to the present day, of convergence of national copyright laws. Convergence has encompassed three intertwined trends. First, the elimination of discrimination against foreign authors. Second, the mitigation of variations across countries. And third, a steady increase in the scope, strength, and duration of copyright protection in all countries. These are important, so I'll repeat. First, the elimination of discrimination against foreigners. Second, the reduction of variations across countries. And third, a steady increase in the scope, strength, and duration of copyright protection. There's no logical link between those three dimensions. For example, you could imagine harmonization having been achieved through universal adoption of the least common denominator, the laws of the least protective country. In other words, we could have seen a leveling down rather than a leveling up. How and why the three trends nevertheless have been linked historically is one of the major issues in the legal history of copyright. I hope by the end of these lectures you'll have a better sense of the possible answers to that question. The primary vehicle of this process of convergence was a series of multilateral agreements, treaties or analogous deals among many countries. Since the late 19th century, there have been 6 major multilateral agreements implicating copyright law. They're listed on the map in front of you. The Berne Convention, the Universal Copyright Convention, the International Convention for the Protection of Performers, Producers, and Broadcasting Organizations, which is commonly known as the Rome Convention, the Agreement on Trade-Related Aspects of Intellectual Property Rights, which is commonly known confusingly as TRIPS, the 1996 treaty, adopted under the auspices of the World Intellectual Property Organization, commonly known as the WIPO Copyright Treaty, and the contemporaneous WIPO Performances and Phonograms Treaty. All of these agreements are complex. I'm not going to attempt here to walk you through their various provisions. That would take too long, and you would not remember the details. Instead, in this lecture, I will identify the most important general themes of these agreements. Then, in subsequent lectures, when addressing specific sets of legal rules that have been shaped or constrained by these treaties, we will return to the relevant treaty provisions. The two most important agreements are the Berne Convention and the TRIPS Agreement, so we'll spend most of our time on those. The Berne Convention is the grandparent of these multilateral agreements. It was the first to be adopted. The negotiations that resulted in the Berne Convention began in 1858 and were finally finished in 1886 with the adoption by 10 countries of the original version of the convention. Since then, it's been revised 7 times. If you click on the icon associated with the history subtopic in the map, you'll find a series of slides that provide details concerning the evolution of the Berne Convention, when different provisions were added, how many countries signed on to each one, and so forth. Today, the convention has been joined by 166 countries, extending its reach over most of the world. Here's a map showing its coverage. 3 dimensions of the current version of the Berne Convention are crucial. The first is the so-called national treatment principle. Prior to the Berne Convention, some countries have been chipping away at the widespread practice of discrimination against foreign authors through adoption in bilateral treaties of the so-called reciprocity principle. As its name suggests, the reciprocity principle depends upon 2 or more countries, each extending rights to the residents of the others. Country number 1 agrees to grant copyright protection to the residents of country number 2, if and only if country number 2 grants copyright protection to the residents of country number 1. The Berne Convention, and as we will see, all subsequent multilateral agreements, repudiate the reciprocity principle in favor of the simpler and more powerful national treatment principle. The key idea in national treatment is that country number 1 must grant to the residents of country number 2 the same rights it grants to country number 1's own residents. To illustrate, today, French authors are given the same rights in the United States as are given to US authors, and US authors are given the same rights in France as are given to French authors. The application of this principle in the Berne Convention is actually somewhat more encompassing than I have thus far suggested. As the map indicates, the Berne Convention requires each signatory country to grant to, quote, protected authors, end quote, the same rights it accords to its own nationals. If you follow the links in the map, you'll see that the term protected authors is quite capacious. The net effect is to require all member countries to extend the benefits of their copyright laws broadly. In one respect, however, the application of the national treatment principle in the Berne Convention is less encompassing than I have thus far suggested. Specifically, the Berne Convention does not apply to what are called neighboring rights. This is the term used in many countries to describe the legal rights of performers and producers. They are said to be neighboring rights because they are adjacent to copyrights, but not true copyrights. Such neighboring rights are governed not by the Berne Convention, but by the Rome Convention. The geographic coverage of the Rome Convention is substantially smaller than that of Berne. As of today, namely January 7th, 2013, 91 countries have joined the Rome Convention. Among the major countries not participating is the United States. We'll return later in this series of lectures to the ways in which the Rome Convention affects the definition and scope of the rights of public performance. For present purposes, the crucial point is that the members of the Rome Convention are permitted to discriminate against the residents of non-member countries, including US nationals. And they do. Here's an example. France imposes a levy on sales of blank tapes. The money raised by that levy is distributed as follows. 25% is devoted to French cultural purposes, 25% is paid to the composers of the musical compositions recorded on those tapes, 25% goes to the performers of the recordings of those songs, and 25% to the producers of those recordings. US composers get a share of the second slice because musical compositions are governed by the Berne Convention, and thus France may not discriminate against U.S. authors. By contrast, U.S. performers and producers are excluded from the third and fourth slice because their interests are not governed by the Berne Convention. The question that this example leaves open, of course, is why the United States is not a party to the Rome Convention. We'll take up that issue and its implications for U.S. performers and producers in lecture number 8. So, to review, the first key dimension of the Berne Convention is national treatment, the principle that each member country must extend to the residents of other member countries the same rights it extends its own residents. The second and third of the major dimensions of the current version of the Berne Convention is the prohibition on formalities. As the map indicates, the key idea here is that member countries may not impose upon protected authors any administrative obligations that they have to satisfy in order to acquire, enforce, or maintain their copyrights. Curiously, member countries may impose such obligations on their own nationals, and occasionally they do. But, as one might imagine, discrimination against one's own citizens is rare. This prohibition on formalities creates a very sharp contrast between copyright law and patent law. Roughly speaking, while copyright law protects works of authorship, patent law protects inventions. To obtain a patent, an inventor must comply with myriad administrative requirements. Typically, he or she must apply for a patent within a limited period of time and must demonstrate to the satisfaction of a patent examiner that his or her invention is useful, novel, and non-obvious. Most patent applicants in most jurisdictions eventually succeed, but not all. And compliance with these requirements is always costly. Copyright law, in the overwhelming number of countries that adhere to the Berne Convention, is radically different. In those countries, there are no administrative preconditions to the acquisition or enforcement of copyright. So, for example, if you happen to be taking notes while watching this lecture, and your notes contain a bare minimum of creativity, topic to which we'll return shortly, then you have acquired a copyright in your notes. Similarly, if you take a snapshot of your family and that photograph is minimally creative, then you acquire a copyright in the photograph. No formal grant, no governmental imprimatur is necessary. Historically, what underlay this hostility to formalities? The traditional explanation is that the countries most influential in the shaping of the Berne Convention subscribed to a so-called natural rights theory of copyright. If an author's control over his or her creations is a natural right, then the interposition of governmental formalities would seem unacceptable. Chris Sprigman, who has written most insightfully about this issue, persuasively argues that this traditional explanation is unconvincing. It's more likely that the drafters of the Berne Convention, at least the provisions pertaining to formalities, believed that disparate administrative requirements in different countries would frustrate authors' ability in practice to secure global protection for their works. Whatever the reason, the current draft of the convention is firmly set against formalities. This issue might seem technical and unimportant, but for two reasons it's not. First, lawmakers in some countries have long been hostile to the Berne Convention's prohibition on formalities. The premier example is the United States, which, as we will see, retained many formal requirements for copyright protection until late in the 20th century. Reluctance to surrender those requirements helps to explain why the United States did not join the Berne Convention until 1989. The second reason is that, as we will see in lecture number 6, an unexpected byproduct of the absence of formalities is that our social environment is increasingly clogged with billions of modestly creative cultural products over which someone enjoys copyright protection, but persons who wish to make use of those products have no effective way of ascertaining the identity of the owners of the copyrights. Copyrights, as we will soon see, are everywhere, but finding out whom they belong to is often infeasible. As a result, some scholars and lawmakers advocate the reinstatement of formal requirements for copyright protection. The result, they argue, would be to reduce sharply the number of copyrighted works and thus the density of the legal soup through which we daily move. The principal impediment to such a reform is the Berne Convention. The third and last of the main dimensions of the Berne Convention consists of a set of obligations imposed on all member countries to establish minimum levels of copyright protection. For example, member countries must extend copyright to certain kinds of works, must grant the authors of those works specific exclusive rights, must allow those rights to continue for specified periods of time, and so forth. The details of those minimum standards will be examined in subsequent lectures. For present purposes, the main point is that although the Berne Convention has lots of such requirements, it contains no effective mechanism for punishing member countries when they fail to comply with their duties in this regard. As a result, countries that want the benefit of the Berne Convention but don't want to comply with all of its obligations are free, as a practical matter, to join up and then delay or refuse to comply with the provisions that they find unattractive. The United States, between 1989 and 1994, definitely fell into that category. The posture of the United States changed substantially with the adoption of the TRIPS Agreement. The history of the negotiations that resulted in the TRIPS Agreement is intricate, much too intricate to be explored here. If you're curious, the chronology is reviewed in the series of slides that can be accessed through the link associated with the subtopic origins. Today, geographic coverage of the TRIPS Agreement rivals that of the Berne Convention. All member countries of the World Trade Organization, currently 157 nations, are subject to TRIPS. In important respects, the TRIPS Agreement parallels the Berne Convention. Like Berne, TRIPS adheres to the principle of national treatment. Also like Berne, TRIPS imposes on member countries the obligation to establish certain minimum levels of copyright protection. As the map indicates, these obligations pertain to the kinds of works that are subject to copyright protection, including, for example, computer software, the entitlements that copyright owners must be given, the duration of copyrights, and so forth. We'll return to the details under these headings later. That said, TRIPS differs from the Berne Convention in three major ways. First, it imposes upon member countries obligations not merely to establish legal rights, but also effective remedies when those rights are violated. Some of those remedies, for example, pertaining to the availability of preliminary injunctions, were more expansive than some member countries had previously adopted, and so required the adoption of new laws. Second, the Berne Agreement, because it's part of the General Agreement on Tariffs and Trade, has, unlike the Berne Convention, a mechanism for compelling member countries to comply with their obligations. Specifically, the GATT contains a dispute resolution procedure that enables a member country to initiate a complaint against another member country that has failed to live up to its TRIPS obligations. Details concerning the handling of such disputes can be found by pursuing the links in the map. The principal remedy imposed upon a country found to have failed to comply with its obligations is so-called cross-sectoral retaliation. In other words, the complaining country is permitted to impose trade sanctions on other goods. This process is far from perfect, but it does have teeth. The third of the three respects in which the Berne Convention differs from TRIPS is related to those teeth. As you can see from the map, the TRIPS Agreement incorporates by reference all of the obligations imposed on member countries by the Berne Convention except one, Article 6 BIS. What's that? That article, it turns out, is the provision of the Berne Convention that governs moral rights. You'll recall, I hope, that moral rights are given much shorter shrift in common law countries than in civil law countries. The result of the exclusion of Article 6 bis is that countries such as the United States, reluctant to adhere fully to the Berne Convention obligations with respect to moral rights, are still able to do so without running the gauntlet of WTO dispute resolution proceedings. The TRIPS agreement is the most controversial aspect of copyright law, indeed of the law of intellectual property as a whole. Debate concerning the merits and demerits of TRIPS, and in particular whether it's been good or bad for developing countries, has been intense since the agreement was first adopted. If you follow the link associated with the subtopic merits and demerits, you will find some slides summarizing the principal contending positions on this issue. Later in the lecture series, once we have on the table more information concerning the actual impact of TRIPS, we'll come back to this fundamental issue. Two 1996 treaties, both of them negotiated and administered by the World Intellectual Property Organization, remain to be considered. They have identical geographic coverage. Currently, 90 countries subscribe to both. The first requires member countries to expand somewhat the rights of authors. The second requires member countries to expand the rights of performers and producers. The most novel and important provision in both of these treaties is the obligation imposed on member countries to reinforce technology protection measures. Specifically, both treaties require member countries to penalize in some way the circumvention of encryption or the removal of information contained in copies of copyrighted works that identify their owners. A major branch of copyright law has grown out of these treaty provisions. We'll consider that branch in lecture number 11. Overlaid on the pattern of obligations created by these multilateral agreements are a few regional agreements which further constrain the freedom of member countries to shape their national copyright laws. The most prominent of the regional agreements is the European Union. Several EU directives listed on the map oblige countries within the region to manage their copyright systems in particular ways. Less well known is the African Intellectual Property Organization, commonly known as OAPI, the members of which are subject to similar obligations. We'll take up the details of those regional directives later. The framework created by this welter of multilateral and regional agreements is not stable. On the contrary, countries and major interest groups within those countries struggle constantly to tilt the framework in their favor. Sometimes the struggle involves the interpretation of existing provisions. One of the most important of those provisions is known as the three-step test. This is not a separate treaty, it's rather a recurring norm, variants of which can be found in most of the treaties we've already reviewed. These variants are not identical, but they're similar. Shown on the screen is the version contained in the Berne Convention, specifically in Article 9.2 of the Convention. I've inserted in brackets letters that divide the so-called three-step test. With those insertions, the provision reads, "It shall be a matter for legislation in the countries of the Union to permit the reproduction of such works, A, in certain special cases, provided that, B, such reproduction does not conflict with a normal exploitation of the work, and C, does not unreasonably prejudice the legitimate interests of the author." The TRIPS agreement contains a similar provision, although note that the TRIPS version, unlike the Berne provision, applies to all exclusive rights enjoyed by copyright owners, and not merely to the right of reproduction. Analogous provisions can be found in other treaties. What's going on here? What these provisions are designed to curb is the impulse of some countries to limit the scope of copyrights by granting exceptions or privileges to users who wish to employ copyrighted works in ways that would otherwise be illegal. The basic idea underlying the three-step test is that such exceptions may not cut too deeply into the rights of owners. But how deep is too deep? The language of the treaty provisions is notoriously vague on that crucial point. As a result, many different interpretations of the three-step test have proliferated. Some are quite strict. If widely adopted, they would require the United States, for example, to abandon or at least significantly curtail its fair use doctrine, which we will consider in detail in lecture number 9. Others are substantially more permissive. An intermediate position on the spectrum of interpretations, which has much to recommend it, is the interpretation offered by Bernd Hugenholtz and Ruth Akediji, which is set forth on the map. Here's the gist of their argument. Limitations and exceptions that 1, are not overly broad, 2, do not rob right holders of a real or potential source of income that is substantive, and 3, do not do disproportional harm to the right holders, will pass the test. The debate concerning the meaning of the three-step test will likely continue for quite a while. Another source of instability in the international framework is that countries, often nudged by interest groups within them, are constantly attempting to supplement the treaties we have considered with additional bilateral or multilateral agreements. 4 ongoing efforts of this sort are listed in the map. The Anti-Counterfeiting Trade Agreement, commonly known as ACTA, has been under negotiation since 2006. It differs from all the treaties we've considered thus far, both in the small number of countries that were involved in the negotiations, and even more importantly, in the fact that those negotiations were conducted largely in secret. Despite considerable resistance to that secrecy and to some of the substantive provisions that emerged from the negotiations, ACTA looked well on its way toward ratification and adoption until July of 2012, when the European Parliament, responding in part to growing public concern, balked. Whether ACTA will ever enter into force is now doubtful. Next in line is the so-called Trans-Pacific Partnership Agreement, or TPP. This too is being negotiated by a small group of countries in a series of confidential meetings, the most recent of which was held in New Zealand in December of 2012. The countries involved claim to be aiming to wrap up an agreement by the end of 2013. The secrecy surrounding the negotiations means that we can't be sure that the TPP will contain any specific provisions, but some possibilities contained in leaked drafts are set forth on their map and would, if adopted, be quite substantial. More modest in ambition, and thus less controversial, is the Beijing Treaty on Audiovisual Performances, which we will discuss in lecture number 8. Last but not least is the draft WIPO Treaty on Exceptions for the Visually Impaired. This is a traditional draft treaty in the sense that it is being negotiated openly and under the auspices of WIPO. But it's highly unusual insofar as at least some draft provisions would authorize or even require member countries to create an exception to the rights of copyright owners, sufficient to allow the preparation and distribution of copies of their works in formats that are usable by blind persons. In other words, this is a treaty that would, if adopted, curtail the rights of copyright owners rather than expand them. That's very rare. Major aspects of the treaty are still up for grabs, such as whether it will contain a three-step test, which would, as a practical matter, limit its value. If those disagreements are resolved, we might see a finished draft in Morocco in June of 2013. The general point is that while the broad contours of the intellectual property international framework are firmly in place, many important details are in continued flux. This concludes our preliminary review of the structure of the international framework. My ambition in this section has not been to itemize all of the features of that framework. That would be impossible in a single lecture or even an entire course. Rather, my goal has been to convey to you the key principles and trends and to mark the locations of the treaty provisions to which we'll return later when examining specific features of copyright law.